Good morning, everyone. Welcome back to our channel for continuation of our criminal law series. Those who are attending today for the first time, please ensure to go back to our channel and watch the previous discussions. In today's live session, we shall unravel the strategies and procedures for quashing a criminal case against your client
Today's
in the
live session, we shall
Understanding the legal avenues available for challenging and criminal charges is very crucial for safeguarding your client's rights and interests. In this session, we will delve into the nuanced aspects of filing a quashing petition, presenting compelling arguments, and navigating the judicial process quite effectively. Whether you are a legal professional seeking to expand your expertise or a concerned individual facing unjust accusations, this session is for you. Don't miss this opportunity to gain valuable insights and empower yourselves with the knowledge to seek justice for your client. Tune in and learn how to navigate the complexities of quashing a criminal case in the High Court. I welcome back our speaker for the session, Beeta Bajwa, an accomplished criminal lawyer with an impressive 14 years of experience specializing in criminal trials. Welcome, ma'am, and over to you.
Thank you so much, Spartileka. Good morning, everyone. So today's topic, which we are going to be covering up, is how to get your proceedings quashed in the High Court. Now, this is a major, a difficulty and a major error which a lot of people do is that whenever quashing comes to, everybody resorts to now Section 482 of the CrPC. Now, this is the basic difference which I was taught in the starting of my career by my senior. So I remember that we always used to say, and I still remember till today that whenever seniors to come and ask us, we say quashing under what beta, and we used to get up and say, sir, section 482. So he used to say, no, quashing is not only under 482. Why we go under 482 is because section 482 of CrPC are the inherent powers of the High Court, by which it's the High Court which has the powers to quash a proceeding or an FIR. So that's how we are going to start our lecture by today. We're going to be covering up section 482 of CrPC. So section 482 of CrPC, that is the inherent powers of the High Court, are not only limited to quashing, it can be invoked in other cases in which there is no specific provision under the CrPC, and for which it is only the High Court which has the discretionary power to enter and pass orders. But today we are going to constrain ourselves only with the quashing powers of the High Court under section 482. So now coming down to section 482 of CrPC, what exactly do you mean by quashing? What are the cases for which quashing can be filed? Also, whether at what stage quashing can be filed before the High Court. So there are two types of quashing. One you have, we call as the quashing of FIR. Okay, that is at the stage when the FIR is registered, and on the face of it, if the FIR is false, if it is bogus, if there are no case made out, if it has been filed with a personal vendetta, then you can go to the High Court seeking quashing of the FIR. In the event, prima facie, a case is made out in the FIR, and after going through the FIR, if you feel that this is not a fit case wherein the High Court is going to exercise its inherent powers, what do you do in such a case? You wait for the police to file its charge sheet. That is the final report under section 173 of the CrPC. What exactly is the charge sheet? What exactly is a final report? A charge sheet is that in offenses which are punishable for less than 10 years, 10 years and less than 10 years, the police has to file a charge sheet, that is a final report of its investigation, whatever investigation they have conducted, including the recording of statements of the witnesses, including the evidences collected by them, including whatever evidences which has been collected by them. That can be recovery, it can be the forensic report, it can be, if it's a rape case, in the case of a rape case, it can be the medical report of the rape victim. In case of murder, you have something which we also call as a blood grouping, in wherein the blood of the accused, blood of the deceased is sent for blood grouping for forensic analysis to check whether the blood stains, if recovery of, if for example, say if there is a recovery of blood stained clothes, if there is a recovery of a weapon or a knife which has a blood stain on it, whether that matches the blood of the deceased, and if there are fingerprints, if there, so whether the fingerprints match that of the accused, if there is recovery of a weapon or a gun, whether that gun has the fingerprints of the accused, and if there are bullets, you have something which we call as a ballistic report. Now, what do you mean by ballistic report? That whenever a gun is fired, bullets are fired and the bullets are seized by the police on the spot, they will send that bullets for forensic analysis to check whether these are the same bullets which has been fired from the same gun, and that is why that is called as a ballistic report. Now, coming down to your final report, you're in under the investigation. Once the police completes the investigation, so as I said, when the offenses are 10 years or less than 10 years, then the police has to file the charge sheet within 60 days. When the offenses are above 10 years, the time for the filing of the charge sheet is 90 days. So within 90 days, they have to file the charge sheet. Once they file the charge sheet in the court, notice is issued to the accused and a copy of the charge sheet is provided to him. That is when you decide on the basis of the charge sheet that whether, as per the material which has come in the charge sheet, as per the evidence which has been collected by the police in the charge sheet, whether an offense prima facie is made out against your client, whether charges needs to be framed, and whether it is a fit case for quashing. As I said in the earlier sessions also, many a times an accused is only arrested on the basis of the statement of the co-accused, which, as I said, would be inadmissible and hit under by section 26 of the Indian Evidence Act. In such cases, you can go for quashing. If in the event you have statements of witnesses which come in your favor, which are saying, which say that, there is no case made out in this case has been filed against you, take out a personal vendetta, then also you have a good case for quashing. If there is no material seized against you and the only material is against the co-accused and absolutely no recovery from you, no evidence from you, then also you have a good case for quashing. In such cases, you go to the High Court, invoke the inherent powers of the High Court under its writ jurisdiction and under section 482 by filing a writ petition before the High Court. Now, the law has been laid down and the principles has been laid down by the Honorable Supreme Court in the judgment of State of Haryana versus Bhajanlal in the year 1992. The Supreme Court has clearly laid down 7 principles under which quashing of FIR or proceedings can be filed before the High Court. So when you go for quashing of FIR, that is before filing of charge sheet. When you go for quashing after the filing of charge sheet, that is called as quashing of proceedings. That is the basic difference. So always remember that. If you go for quashing of the FIR, at the FIR stage, when there is no charge sheet, that is quashing of FIR. When you go for quashing of the charge sheet, that is called as quashing of proceedings. So, Atilekha, I request you to kindly share the 7 principles of Bhajanlal so that we can appraise everyone about the 7 principles of Bhajanlal. Kindly share it on screen.
I'm already sharing, actually. I'm already sharing. Yes.
Swatilekha is sharing that. Let's continue. Now you have all these 7 principles which the Honorable Supreme Court has laid down. These are the guidelines by the Honorable Supreme Court on what cases and on what basis, if your case falls into any one of these categories, quashing of proceedings is maintainable. Can you please go up for me a little? Can you go down to point number 1? If you read the point number one is very clear. It says that if the allegations in the FIR do not prima facie constitute an offense, they can be quashed. If it is found after consideration that the allegations are not sufficient to establish or presume that there is an offense, that the court can quash the FIR. A basic understanding of this guideline would mean that prima facie in the FIR, you see the statement of the complainant, and if the complainant does not attribute any role to you, or she has levied all the, or he or she has levied all the allegations, on the other accused, or and not only that, in that event, if they also, if you see that their transaction was with the co-accused and this accused had nothing to do with it, and he has only been, made a scapegoat in the offense, then you come down under this guideline. One ground for quashing is non-disclosure of a cognizable offense in the allegations mentioned in the FIR. 156(2) of the CrPC provides an exception to this rule. Police can be investigated in the matter if there is no indication of a cognizable offense. So in the event there is no cognizable offense made out. Now, as I had explained, cognizable offenses are those offenses in which the police can arrest an accused without a warrant. Your example I had given as example, your offenses such as your rape, murder, these are all cognizable offenses. Offenses which are non-cognizable offenses are those offenses in which the police cannot arrest an accused without a warrant and without an investigation. So if an FIR has been registered for non-cognizable offenses, that on the face of it no cognizable offense is being made out, then also the FIR can be quashed. FIR can also be quashed when the undisputed allegations in the FIR fail to establish essential elements of a criminal element. There must be supportive evidence because a criminal proceeding without the accused would abuse the process of the court. It violates the fundamental rights of the accused. This clearly means that in many times, in many cases, you will encounter that criminal proceedings are resorted to for civil disputes so as to pressurize the accused to come and settle the matter, or to harass the accused in such cases where there is no criminal liability made out, in such offenses where there is no criminal case made out, but still the police goes and registers an FIR, it can be quashed. When the allegations only constitute a non-cognizable offense, the police cannot begin an investigation without the permission of a magistrate. This rule is specified under section 155, subsection 2 of the CrPC. Crimes that do not harm to society fall under this purview. This is aimed at restricting the unlimited powers of the police. It safeguards innocent individuals from unwarranted police investigations in cases where the alleged offense is non-cognizable. As section 155 reads, as I had explained, that those are non-cognizable offenses. And non-cognizable offenses, as I said, are those offenses in which the police cannot arrest the accused without a warrant. So in the event you want to proceed against an offense of an NC, you have to go before the magistrate, file a private criminal complaint under section 200, and it is only the magistrate who has the power to order an investigation or to conduct a trial for non-cognizable offenses. Cases where the allegations in the complaint are too absurd and improbable can warrant the quashing of the FIR. It is usually done in cases where the accusations are irrational and way too far-fetched. Must give reasons to initiate and clear reasons to initiate an investigation against the accused. Now, many a times you would encounter in the FIR, in the statement of the complainant, that the complainant will give allegations just for the sake of it, and they would be so absurd, something which will not be supported by any documentary or any evidence for electronic evidence or evidence for that matter. In fact, it may not be supported by any evidence, and there may be no corroboration among the witnesses. The complaint may be saying something else, the witnesses may be saying something else, and if you look at the FIR, a prudent man would, after going through it, would make out that there is no criminal offense made out because the allegations are too absurd. In such cases, the FIR can be quashed. Where there is an explicit prohibition or restriction that pervades prevents the initiation or continuation of criminal proceeding. It highlights cases where there are frameworks that offer alternative remedies that are effective in addressing the allegations made. For example, if you have say alleged perjury. Now, when you come down to offenses under section 195, 196, and so, these are offenses of giving false evidence before the court. In your simple words, we call them as offenses called as perjury, where a person lies on oath. Then you have the provision of section 195 that with 340, for which you can approach the magistrate, file a complaint, and the magistrate can direct a registration of an FIR. If the FIR has been registered directly, even without approaching the magistrate and invoking the powers under and go resorting to the remedy available under section 195 and 340 of CrPC, 195 of IPC and 340 of CrPC, then an FIR can be quashed. But the case is tainted with bad faith and has underlying motive of causing harm, the FIR court. This is the most common of this being that when the FIR has been filed, where there is a personal vendetta, when there is a personal grudge against each other. You would encounter this in a lot of times, for example, say two people are living in the same colony, in the same, gully, and due to which there must be some a fight which could be in between them. Okay, and when this happens, when there is a fight which happens between them, during that time one party goes and files a case against one person, and the other party goes and files a case against the other person. In such cases, the FIR can be quashed. Not only that, the proceedings can also be quashed. This is at time when you go before the High Court and you file a case for quashing, invoking the powers under 482. Now, what would be your defense? Always remember this, and I always say this, that when you go for quashing before the High Court, you would never and ever, say and point out the lacunas in the investigation of the police, but you would point out the lacunas in the investigation already conducted by the police. Because if you resort to the lacunas in by conducted by the lacunas that the police should have done this, the police should have done that, they should have collected this evidence, they should have collected that evidence, then that cases the FIR will not be quashed. In that cases, the High Court will not entertain you. That is the reason, because if you go and you point out the police should have done this, the police should have done that, they should have collected this evidence, they should have collected that evidence. In such cases, then the police has ample powers under section 173, wherein they can go and file a supplementary charge sheet against the accused at any stage. They can go and file a supplementary charge sheet at any stage under section 173(8). So if you take out the lacunas in the investigation which has been conducted by them, at that time you give them the reason, you give them a way to cover up those lacunas in the investigation. So constrain yourself to the investigation which has already been conducted by them. Constrain yourself to the evidence collected by the police and why as per that the FIR needs to be quashed. You also have something which we call as quashing by consent. When is that done? That is done in cases where, for example, say there are cognizable offenses which are made out, but during the pendency of the case, say, or after the filing of the FIR, both of the parties enter into a settlement. Say, for example, your offense is under section 420. Now, I am an accused. I have an FIR under section 420 registered against me. Now, I have settled the matter with the complainant. Now, the complainant does not want to proceed against me, but the offense is a cognizable offense. It's a non-bailable offense. You have something which we call as a table under section 320 of CrPC, which we call as compounding of offenses. Now, what is the table under section 320 of CrPC? Now, if we read the section 320 of CrPC, it has tables, it has two tables, which gives the list of all the offenses, which gives the list of all these sections which are compoundable which can be compounded by the court. So that means if you have an FIR, or if you have a case registered against that relevant section against the accused, you can go before the magistrate and file an application for compounding under section 320, saying that we have settled the matter out of court and the complainant does not want to proceed. But say the accused is being prosecuted for say more than 4 or 5 sections, out of which 3 sections may be compoundable, but 1 section may be non-compoundable. As I said, section 420 or 498A also, for that matter, the most common one. And those 2 offenses are non-compoundable and cognizable. So what do you do in such cases? Then in such cases, again you will invoke the inherent powers of the High Court under 482. You file for a quashing petition before the High Court, which we call as a quashing petition, quashing by consent, wherein the accused files that writ petition, he becomes the petitioner. He makes the complainant, the respondent, as a party. Always remember, in quashing proceedings, the original complainant has to be heard. Original complainant has to be made a party. It cannot be that you cannot quash a case without hearing the complainant. So if you don't make the complainant a party, the High Court is going to direct you to go and make the complainant a party. So you have to make the complainant as a respondent. In quashing by consent also, you make the complainant as a respondent number 1 or a respondent number 2. You don't need to issue notices under to the respondent, because since it is quashing by consent. If it is quashing by on merits, that time when you make the complainant a party, you go before the High Court, argue and appraise the High Court that what exactly is a writ petition and why you have come before the High Court seeking quashing of the FIR of the proceedings, and the High Court will issue a notice to the accused in such case. Whereas in quashing by consent, the question of notice does not arise because it is a quashing by consent petition. There will only be a no objection affidavit which has to be filed by the complainant. When a 1-page affidavit is filed by the complainant where she says that he or she says that they are the complainant in the above mentioned matter, and they have settled the matter out of court, they have amicably resolved their issues, and they do not want to proceed with the matter, and hence the proceeding or the FIR, they have no objection if it is quashed. Now, this is quashing by consent. What do you do when it is not by consent and it is on merit? When it is on merit, first you have to convince the bench as to why your writ petition should be admitted and it should be entertained. Always remember this. You also need to take stay on the proceedings. Why you need to take stay on proceedings? Earlier we used to take stay on the investigation also at the stage of quashing of FIR, but by a recent judgment of the Honorable Supreme Court, it has clarified that investigations of the police cannot be stayed. So the High Court should not blindly grant stay of investigations. And that, what do you do in such a case? Now you can't be remediless. In such a case, now the High Court, what the High Court does is, the High Court does not stay the investigation against the accused, but only stays the filing of the charge sheet against the accused till the time the pendency of the writ petition before the High Court, till the time the High Court decides the writ petition. But after the filing of charge sheet, if you're going for quashing of proceedings, why you need to stay on the proceedings? Because as soon as the charge sheet is filed, the matter is placed for framing of charge against the accused. A framing of charges wherein the accused is put into the witness box and the charges, the sections are read out to him. This is called as framing of charge, wherein he pleads not guilty. This has to be done. And why you need stay? The reason being, if charges are framed against the accused, then the High Court would be a little wary of interfering in the proceedings, saying that since the charge is framed, the trial has commenced, you please go before the trial court and conduct the trial and put all your defense in the trial. So you lose out the opportunity of quashing, and that is why you should and always seek stay of the proceedings whenever there is a charge sheet filed. It always comes to your favor. When you argue for quashing, you have to argue and convince the bench as to why it should exercise its inherent powers and quash these proceedings. Why, what, as per the evidences which has come, as per the case, what exactly is the case, reason why this FIR has been registered. Always remember, in quashing, you can annex your relevant material, your evidence before the High Court. You can file it along with your writ petition, your defense, your documentary evidence, saying that please see, this is what has had happened, and this is the reason as to why an FIR was registered against me. Okay, so remember this. This is how you argue. So when you argue for FIR, when you argue for proceedings, that is how you have to. When you argue for quashing of proceedings, you will not point out the evidence which was collected by the police, what, how it is faulty, how no case is made out, and you can also put your defense before the High Court saying that this is my documentary evidence, or this is my evidence which I had put before the investigating officer, which I had put before the police, but they did not consider it and still went ahead and filed an FIR or a proceeding against me. So that is how you go before the High Court. This is the procedure of filing a writ petition before the High Court. This is how quashing proceedings are to be conducted before the High Court. This sums up your today's topic. Over to you, Swatilekha.
Thank you, ma'am. I would like to have some questions here. So,
Sure.
one, the questions that we can ask here is, can you explain a little bit about a charge sheet here? What exactly is a charge
As I
sheet?
said, charge sheet exactly is the final report filed by the police under section 173. Now, when the police arrests an accused, it conducts an investigation. It records the statements, as I said, it records statements of the witnesses, it collects evidences. It may collect documentary evidences if it is forgery. It may send it for handwriting expert opinion. Okay, if that's a murder case, it collects the blood samples. It collects the recovery of weapon. There is recovery of blood stained clothes that are sent for blood grouping. That is sent for forensic analysis. All this is the investigation which has been conducted by the police. Once that compilation is compiled into one document, including the FIR, the statements of the witnesses, all the evidences, documentary evidence, that is called as a final report, on which, on the investigation conducted, the police concludes that this is the offense which has been conducted by this accused, and they need to be prosecuted for this offense. In such a case, the police goes and files a charge sheet before the court. That is a final report form under section 173. This is what a charge sheet is. That is the investigation conducted by the police.
Got it, ma'am. Whether quashing is maintainable after filing of the charge sheet?
Quashing is maintainable after filing of charge sheet, but it is maintainable before framing of charge. As I explained, it's better that you always approach and take stay, because in the event you don't take stay in the framing of charge, and if the trial court frames charges against your client, then the High Court would be wary and refrain itself from interfering, saying, now the trial has started, you go before the trial court and conduct the trial.
All right, ma'am. And what is the basic difference between quashing and discharge?
Quashing is when you go before the High Court, you invoke the inherent jurisdiction of the High Court under 482. Now, discharge is under section 227 of CrPC and 239 of CrPC. As I had explained, that the offences are bifurcated as per offences which are magistrate triable, offences which are sessions triable. Before the magistrate, your discharge application goes under section 239, and before the sessions, it goes under 227. Why and what exactly do you mean by discharge? Discharge is to be filed before framing of charge, before the trial court, and before which the trial is being pending. In discharge, you have to constrain yourself to the charge sheet only, which has been filed by the police, and the lacunas in the charge sheet. Whereas in a quashing, the scope is very wide. You can go beyond the charge sheet and appraise the High Court of the facts that this is my evidence. But if in discharge you go before the trial court and you go for the trial court judge or the magistrate or the session judge, and you say that this is what the investigation they have conducted, this is my defense, magistrate is not going to entertain your discharge and going to say that you conduct the trial and prove this evidence in your favor. Whereas High Court has that ample power, High Court has that discretionary power. It can exercise and look into that evidence, whereas the trial court would not do that. That is the basic difference. And discharge, always remember this, is before framing of charge. So framing of charge is section 228 and 240, and that is the reason it comes under 227 and 239, which is before framing of charge. So discharge is before the trial court and before framing of charge, whereas quashing is before the high court, and it can go beyond the charge sheet. Whereas in discharge, you have to constrain your arguments to the charge sheet. And as I repeatedly say again and again, please do not go and say that the police should have collected this evidence and the police should have collected that evidence. They have not produced it, because that is your defense. If you disclose it at that stage during the cross examination, the witnesses are going to come prepared with the answer as to why that evidence was not collected. So that's something is which you have to catch them by surprise and catch them, very unaware during the course of cross examination. As defense lawyers and as trial court lawyers, you have to be, even if you're going for quashing, be careful that you don't mess up your trial in the event the high court is not going to exercise its inherent. So your trial should not be messed up, and your defense should be valid over there also. And the defenses which you have taken should be maintainable, and you can get an acquittal for your client. So you have to be careful. This is the basic difference between discharge and quashing.
Got it, ma'am. So thank you, Vinita ma'am, for the insightful session. I hope everyone enjoyed this webinar today. We will meet again next week at the same time, that is Sunday, 11:30 a.m., and continue this series with more practically useful topics and information. Then please take care of yourselves and have a great day to you too, ma'am.
Thank you. You too. Bye, guys. I'll see you next Sunday.